Hi there, Gary Jenkins again. Thank you for watching my videos. If you like what I'm saying, please feel free to subscribe and give me a like. That really helps with the analytics. Let me just get right down to basics here. As you know, I'm on my road from recovery, or I am recovering from redundancy. That's basically what it boils down to. And I've had two questions in the last 48 hours where people have said just exactly what can I do? I've been made redundant. They are both residents of the UK, as I am. So let's just look at this point blank and let's just be really, really honest. Okay? Redundancy is what happens when a company says there's no longer a need for you to do the work you've been told or you have agreed to work or the job you've been told that you're going to be working. So a business is going to close down, or they've made a change in a way that your job is no longer needed. When you have this stressful time, the law is that the company has to bring you in, do a consultation period with you where they discuss your job being removed. It's no longer going to be available. It has to fall in the guidelines that not only is a job not going to be available, it's not going to be available to anybody. Okay, they may have bought a software system, or they're going to go to an AI system that's going to take over your kind of job, or maybe they're just absolutely going to shut down that whole entire department. And they're just not going to be providing that service in-house in the company any longer. And this consultation period is to help you to understand that there are other jobs that are available and what the steps would be for you to get into that job. It is not necessarily that you're going to have a lateral appointment to a similar type job. You may actually be told you can have that job, but it's in a different city. You can have this job somewhere else. So that is all being eliminated. And if it becomes eliminated that, that's just not reasonable for you in your circumstances, then the company agrees that they're going to make you redundant from their system. And by doing that, you're entitled to compensation. And usually it's a certain amount of money based upon the number of weeks with a maximum cap of the amount that they can give you based on your years of service. If you have less than 2 years, all they have to do is just give you 1 week's notice and you're gone. There's no compensation really for your service. Now, if you've given 2 years, believe me, I'm not a lawyer. I'm not a lawyer, folks. I'm just giving you my understanding. And I'm going to tell you that this law is really complex. Labor law in the UK is absolutely complex with a lot of nuances and variances. So what I'm going to tell you is go talk to Citizens Advice right out the bat if you don't have an attorney. If you think that you have been discriminated against, and we're going to talk about that in a moment, there may be organizations who are more able or more geared up to help you with your specific issue. Okay? So let's just assume that this is a straightforward operation. They have eliminated the job. They're not going to put anybody else in this position. A number of positions have been made redundant. You've been told that, and you have been told that following our consultation period, there does not appear to be any work available for you within the company. We are going to give you notice. If you've been there more than 2 years, they have to give you 2 months notice. They give you those 2 months. They pay you for that time period at your regular amount of pay. Now, you'd stay available to come back to work. They have to contact you if your job or they're going to be hiring within the company comes out, they've got to let you come back to work if they call you back in. Now, there's a lot of jobs or companies that have gone through this procedure saying, well, we're just going to get rid of everybody. We're going to open up new jobs, and everybody has to come back and go through an application process with us and be re-interviewed. I don't go into the legal applications with me. If that happens, you do need to go back, because if you tell them, no, I'm not interested in coming back, you may eliminate yourself from the compensation scheme that happens for being eliminated, because they can literally say, we offered them a job and they refused. So this is kind of a cloudy area, but the job has to be very specific with you that this is an opportunity for you to come back to work. It can't be some kind of wishy-washy, would you be interested in coming in to discuss what other opportunities we might have available? No, that isn't going to. It is, we have other opportunities for you. This is what's available. We want you to come back in and have that discussion, that interview. You need to fill out an application, whatever the process is. My understanding is you have to follow through with them. But let's just say that you were made redundant, but you're beginning to wonder whether it's been done correctly or that you're a targeted individual. Now, have you been targeted because of your age, gender, your marital status, your sexual orientation, your religion, your disability, your beliefs? Have you been targeted because you're a member of a trade union or not a member of a trade union? Have you been targeted because of your work pattern? Maybe you were on some kind of part-time or flex time status. It may have been, you may have been targeted because you fall in a certain age group and you are female and you seem to get pregnant all the time and constantly going on maternity leave. And did you get selected for that? You do have a right to go back to the employer and say, I need to know in your selection criteria where I came in, because the employers are allowed to set a criteria for who is staying and who goes. This includes time in service with the organization. This includes the disciplinary actions you may have received. It may not include things that went into your file, like a letter of discipline that came into your file as a warning, and at the end of 6 months it's to be removed from your file. They can't actually say, well, we put those back in the file. No, if they're supposed to be removed, they're removed, and they're not even up for consideration. The employer also can say, well, your attitude at work or your work level wasn't up to acceptable standards. That all starts to get really subjective at this point, because you could have a wrongful dismissal claim in regards to this. Now let's just go with 3 different examples. I've already given you one of young women who are in a certain age range where they are conceiving and bearing children. And let's just say one of the criteria that appears to happen is it's okay for a woman to have 1 child on the company coin, but it's not okay for you to have 2 or 3. And the company says, we've had you on maternity leave 3 times now in the last 9 years. And scuttlebutt in the office was that you were thinking maybe you should have a 4th child. And we decided we're just not going to pay for that anymore. And it's just easier to make you redundant than not. That's just an example. Here's another example. Let's just say that you had a redundancy. They took everybody that was under 2 years, let them go. You're in that 2-month waiting period going out. But during that 2-month waiting period, let's just say, for example, suddenly all the people who were less than 2 years in the company were being brought back in. They all were younger people. And let's say that you're in that category of people who are age 55 plus, who are difficult. You're considered a protected class as aged, elderly, heading towards retirement age, etc. And the company just hasn't hired anybody back from that age category. That may be an issue where you can go and say, I think maybe I need to talk to Citizens Advice, maybe age concern, about the fact I think I've been discriminated. Because what you need to find out is, on this scale of all these people who, that you fit in, let's just say that on that scale you fit in at 75 percentile of the group. There's only 25% of the company that's ahead of you that has been made redundant. And in that process of being made redundant and being in that 75 percentile, anybody who's below you, who has been brought back and you have not been notified, there may be a claim. Okay? Now here's another one. Let's just say that it's interesting to you that individuals who were not brought back or not being brought back were members of perhaps a religious organization or people of a certain faith group. You notice that perhaps people who were members of the Sikh religion, for example, were not brought back, but Muslims were brought back, people who were Hindus were brought back, people who practiced Mormonism, people who practiced Judaism, etc. were brought back. But just that one specific class seems to totally be absent. They may have a claim for wrongful dismissal, because it would almost be impossible to say that a certain group of people or a certain category of people 100% were at the bottom levels of this selection process. You also may have a claim if you find that people who were worth the company for less than 2 years are suddenly all back. And people who were beyond that point in time were not invited back into the company. And so we have to be careful. Go talk to Citizens Advice. Follow the best legal counsel you can find. Because remember, in the UK, the employment law is extremely complex. It's highly specialized. And there have been a lot of court cases that seem to hang on the precedent being on the most vague of points. But those points exist, and they are points in law. And the other thing that I will tell you is that you do have to go through the tribunal process. And you do have a right to appeal the decision to make you redundant. You'll have to find your company handbook for the employees. There will be a policy there on any appeal process in their decision making. And you will have to follow those steps. Usually, it will say that you must file your appeal within so many days. You have to allow the company a certain amount of time to respond. It will say that once they receive your appeal, they will notify you of receipt and how many days you have for the first level of this appeal process. If they find against you, then you are told what your next step in the appeal process is within the company. It may be that you file again your agreement or your grievance or your points of view, and it will be reviewed by somebody at a much higher level of decision making in the company. And it may be that their decision is final as far as the company is concerned, at which point you would then appeal to a tribunal if you really think that you have been wronged. They cannot use this redundancy process as a means to bypass a elimination, a review that should have taken time to put somebody out of the company anyways. There is so much precedent in UK law where they have made a section redundant, but the person they considered the troublemaker, the person they wanted to get rid of, was not brought back, but everybody else was. And that person finds out after the fact that everybody else was back to work. They just were never contacted or offered their job. And that is not how a constructive dismissal is to occur in the UK. And you have real good grounds in those situations. So I'm sorry this video has been a bit long. I hope this has been packed with some information. Please go talk to Citizens Advice. They can direct you further. Go talk to, if you have, you're in the category of your old age concern, if you're suffering from some form of disability and you think that may have been a factor, that people who've had, let's just say you've been fighting cancer for years and you find that everybody who's fighting cancer suddenly is out on the redundancies. They've never been asked to come back, but other people have. And you think that you had more time, you think you had good scores, etc. And please do use your employee reviews. I noticed with my former employer, oftentimes my reviews were never returned to me by the company because they were saying, oh, we're so busy, we'll get back. And you got really busy in work and you just kind of forgot about it until the next year when you had to go do the annual review again. But if you went in and they didn't follow their process with those reviews, you have grounds. You have grounds. What they say now doesn't count because you have grounds that they never followed through their employee process. So you might want to consider that if that is what you want to do. Okay? It's been good being caught up with you. If you have any comments, please give them below. Remember, I'm not a lawyer. I'm not giving you legal advice. I am advising you to go talk to people who can help you. Okay? Thank you much. Bye.